Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 104. Where did the last fortnight go? Really doesn't seem 2 weeks since I did the last podcast. I don't know what you've been doing over the last couple of weeks, but one of the things I managed to do was visit the Wallace Collection here in London, where annoyingly a number of my favourite paintings have been rehung into rather less suitable positions. I've read The Girl with All the Gifts, which is fantastic by the way. I think I read it in something like 36 hours over one weekend, and I spent more money on CDs than was probably sensible. Anyway, on the business front, instead of having my usual 3 cases, we've got 2 cases and some thoughts on the new judicial assessment protocol for employment tribunals. As usual, don't forget you can access the podcast via iTunes, it's on the Mayor Brown internet, it's YouTube, and the Twitter feed Nicholas Robertson at NicholasRobbo11, and that's where we post out links to all the cases discussed. Let's start with the 2 cases. Salvation Army Trustee Company and Bai and others. This is a case to do with service provision changes and whether or not there's been a TUPE transfer. I don't claim the case significantly alters the rules on service provision changes, but however, it is a useful illustration of how the courts will try to establish the similarity of activities before and after a possible transfer. Legally speaking, of course, service provision change rules under TUPE apply, amongst other things, when activities which have ceased to be carried out by a contractor on a client's behalf are now going to be carried out by a subsequent contractor on the client's behalf. Either way, if it's a service provision change, it's a precondition that the activities being carried out after the alleged transfer are, quote, fundamentally the same as the activities carried out by the person who has ceased to carry them out. And that's Regulation 2A. The context for the case was that the claimant was employed by CCL, which is a charity working in He was working in their adult services team, providing a range of services to homeless people. Typically, the CCL services involved an assessment of potential service users, allocating a care worker whilst they lived in supported accommodation, then the individuals would receive a tailored support plan, and then a looser support, floating support it was called, when they were ready to move on. The council, the end user, decided to simplify things, because the range of services provided to the homeless came through something like 22 separate contracts with different providers. He put the whole lot up for grabs, and the Salvation Army Trustee Company, SAT, won the day. It provided the services via an assessment central hub that dealt with all the references, and, where possible, private accommodation with floating support was provided, but otherwise there was an assessment unit and a support care plan which could be supported with accommodation situated in 2 large hostels rather than multiple houses. There were differences between the services. The services were provided to those over the age of 25 rather than the age of 18, which was where the CCL services had started. The length of time people could stay in supported accommodation became a maximum of 112 days rather than 12 months or indeed 2 years on occasions under CCL. The hours of work for support staff were also different. The tribunal found that there had been a TUPE transfer and that the fundamental activity was the provision of accommodation and the input of support work to facilitate the individual returning to mainstream private accommodation, private life. They did not consider there was a significant difference between having a 24-hour concierge in attendance compared with on-call 24-hour support. The combining of the supportive accommodation into 2 hostels as opposed to a variety of dispersed accommodation was also not significant. So, having found that the fundamental activity was a provision of accommodation and that Coventry City Council were measuring the outcome in providing the services in an identical way, the judge decided that the activities were fundamentally the same. SAT appealed to the Employment Appeal Tribunal, but the appeal was unsuccessful. First, SAT argued the activities had not been properly defined, the business activities hadn't been properly defined, and they said that's essential if there's going to be a comparison as to whether or not the activities are fundamentally the same, before and afterwards. It was asserted the employment judge's description of the activities carried out by CCL was too general and too simplistic. They said the support given at 10 dispersed homes by CCL as opposed to 2 hostels, and the fact it was given for up to 2 years as opposed to 112 days afterwards, after the alleged transfer, these were key aspects of the activities which had undoubtedly changed. The EAT said that in defining the relevant activities, it was necessary to steer a middle way. They gave the example that a fully catered canteen could be described as the provision of food to staff. That would be too general, because it was clearly more focused than that. Conversely, it was important the definition should be holistic and avoid too narrow a focus, because that would risk defeating the purpose of the service provision change rules. In my terms, that would mean then that insignificant differences would be elevated into major changes. On that basis, the EAT considered the activities were fundamentally the same. Equally, the second argument on appeal, an attempt to assert the tribunal judge had failed to consider whether the activities were fundamentally the same, because he had instead made comment about what were the fundamental differences between the activities, well, that part came unstuck. EAT was not going to agree with that, and they said in practice the judge had considered whether the activities were fundamentally the same, in accordance with the legislation. Clearly this case concerned a very specific set of facts. However, I think it's useful in trying to identify how a court will approach evaluating these activities, and whether they are fundamentally the same before and after an alleged transfer. Some differences may be essential, others may be rather more cosmetic. Here, the age of the recipients of the service, the length of time they could stay, and the fact that they were housed in 10 houses dispersed around Coventry rather than 2 hostels did not change the fundamentals of the provision of the services. The only other point to mention is that the judge commented it was 2 charities who were slugging it out here, and although he accepted the dispute was an entirely genuine one, he said that some form of speedy dispute resolution would be highly desirable to enable the parties to get a speedy ruling, rather than spend a lot of time and money on this sort of dispute. I wonder if that's a seed that will sprout at any point in the future. So, that's the case of Salvation Army Trustee Company and Bailly and others. So, second case is Briley and others and Asda Stores Limited. And this, of course, is the equal pay case, which is being pursued by employees of Asda, which gathered a lot of press a couple of years ago, goodness me, a couple of weeks ago when it was decided. Before I go into any of the details, I did just want to make the point. It does feel as if employment law is moving centre stage again in terms of newsworthy cases. For example, we've had this case, which is all over the news, dealing with equal pay and the private sector. We've got the Uber decision, which I intend to deal with next time round. And the Supreme Court are going to hear a challenge to tribunal fees, which will be high-stakes drama for the government. It does feel like the heady days of the mid-80s, when the industrial action laws were gathering similar publicity. And that's before we get to the head rush that is the Article 50 case, which was decided this morning. Anyway, the Asda case, what does it say, and is it significant? Well, at this stage it's a preliminary hearing for starters, and it says a lot. It's a 53-page decision. This is a short summary, so I'm just going to pick out some of the key points. I can't possibly cover all the aspects. However, I think the fundamental point to bear in mind is that this is simply a preliminary hearing relating to the technical issue of what jobs can be compared with other jobs. So, think of it as a gateway case, enabling the proceedings to go ahead. The merits of the case are as yet entirely untouched. In particular, the tribunal has not begun establishing whether the employees are doing jobs of equal value, whether there's a defence to that claim, if there is equal value, and also what would the remedy be even if it gets to the end of the day and the claimants are right. Well, going into this into a little more detail, we've been saying for a number of years now that equal pay is the next big thing for the private sector. I think the Asda case exemplifies why unions or claimant law firms with enough resources to take the fight to employees are willing to do so. I've seen estimates that the potential hit to Asda from this case is £100 million. Well, that, I have to say, looks like a suspiciously round number. But if that is the sort of number, it's no wonder that claimants and respondents alike are both happy to reach for top legal teams and take all the points they possibly can. Bearing in mind, of course, the case is still continuing. A summary of the as yet not yet fully determined facts is as follows. There's something like 7,300 claimants. Most of them are women working in retail stores in hourly paid jobs. They are claiming equal pay with men working in distribution depots. Apparently the distribution jobs are done overwhelmingly by men. The claim is that the work the claimants do is of equal value, but that the comparators, the men in the distribution depots, are paid more than the female claimants. It's suggested this is because the retail stores are seen as women's work, or were seen as women's work, and the distribution depots' work was seen as men's work. So the question for the tribunal only at this stage was whether the employees at Asda stores could use employees working at Asda depots as comparators. However, that simple question masked a number of subsidiary points, not all of which I'm going to go into here. First of all, however, it was necessary to decide whether the claimants could rely on the Equal Pay article in the EU Treaty, Article 157, to base their claim. If that was not possible, then was it possible for them to claim under the Equality Act 2010, the UK legislation, and the equivalent provisions in respect of periods prior to that, the old legislation? The evidence given by the parties indicated that Asda started as a retail operation, now has something like 630 stores, with 133,000 hourly paid employees. More than 20 years after it had been founded, it set up its own distribution operations, to the point where they now have 24 distribution depots with 11,600 hourly paid employees. In general terms, workers in the distribution depot, employees in the distribution depot, do not work at the stores, and vice versa. Retail terms apply to all employees in the stores, common contract. There seems to be a high degree of similarity across these stores, although there were some variations. The picture of distribution seems to be a bit more complicated from the tribunal summary, and it's not as uniform, caused partly by collective bargaining arrangements which apply to distribution depots, but don't apply in the retail stores. The Employment Tribunal started with considering whether a claim was permissible under EU Article 157, which, if there is to be a pay comparison, it says there needs to be a single source controlling the terms. That's not the same as saying there has to be a single employer. Indeed, cases have established that a single source can be wider than an employer. On the other hand, on occasions, a single employer is not a single source. The tribunal decided that Article 157 was directly effective and therefore could in principle be relied on by the claimants. Asda had tried to argue that because there would be a need for further evidence to determine the ability to claim, the article itself could not be directly effective, and this argument was rejected. The tribunal accepted there also had to be a single source for the discrimination in order for a comparability claim under Article 157 to be permitted. It was not necessary for there to be a single employer and a single source. Unsurprisingly, since Asda employed both the staff in the retail stores and the distribution depots, it was found that there was a single source for terms and conditions which applied to the claimants and their comparators. The Executive Board of Asda had sufficient budgetary control and oversight over distribution and retail, and so, for example, could have introduced equality if they wished to do so, according to the tribunal. Turning to domestic law under the Equal Pay Act, and then the Equality Act, it's permissible for an employee in the same employment to compare themselves with employees at a different establishment if common terms and conditions are observed, either generally or for employees within a relevant class. This was then modified in the 2010 Act to apply if common terms applied generally as between the claimant and comparator. Parties accepted the terms had to be substantively comparable, and the tribunal again concluded there was a significant correlation or comparability in a broad way between the terms enjoyed by retail employees and the terms enjoyed in the distribution depots, and moreover the handbooks were similar. So they concluded a claim could be brought under both Article 157 and the Equality Act 2010. I think the case is undoubtedly an important one. This is probably going to be one of those cases which throws up a number of reported decisions on preliminary matters, clearing pathways for others to follow. Here, the tribunal knocks on the head the arguments around Article 157 and whether or not common terms and conditions exist, in a way which enables the case to move forward. If other employment tribunals take the same robust point of view, it would seem likely that tribunals will be keen to grapple with the merits of claims for comparable pay, rather than be deflected with the technicalities. I should add, I don't know whether Asda are considering an appeal. Clearly it wouldn't surprise me to learn that this was the case, and it might yet go on appeal, even on this preliminary basis. Certainly I think this case will keep making headlines for a while yet. So, that's the case of Brearley and others and Asda Stores Limited. So, third thing I wanted to talk about was judicial assessments. And I wanted to break with a hallowed podcast tradition and discuss the presidential guidance under Rule 3, which is the new protocol on judicial assessments. I think this is an interesting attempt to help parties take a realistic view about the potential litigation at the start of the litigation. And obviously this is helpful for both employers and employees. It also chimes quite neatly alongside the comments made in the Salvation Army case about the benefits of speedy assessment and resolution. The presidential guidance came out at the start of October this year and starts the premise that the overriding objective is to enable employment tribunals to deal with cases fairly and justly. Rule 3 allows a tribunal to encourage the use of ACAS, mediation or other means of resolving disputes by agreement. The guidance sets up a protocol for an employment judge to conduct an informal judicial assessment of a claim and the response as part of the preliminary hearing. It's anticipated that it will be, quote, particularly helpful but not exclusively so, unquote, where one of the parties is not professionally represented. The potential benefits ought to be to identify what the case is really about and what is at stake, and that in turn may narrow issues and encourage settlement. The guidance says that judicial assessment will be offered generally for the first case management hearing, after the issues have been clarified. It will generally not be offered if there are multiple claimants and some of them do not want judicial assessment, or there are High Court proceedings envisaged. If parties want to take advantage of the process, they are encouraged to ask the tribunal ahead of the case management hearing itself to enable the judge to prepare. A judicial assessment process will not generally be offered later on in the proceedings. I think this is probably to ensure that the parties focus early on this, so as to get the best out of the process before positions perhaps become entrenched. In paragraph 14 of the note, it's stated that it is, quote, a requirement, unquote, for judicial assessment that the parties freely consent to it. Quote, no pressure should ever be placed on any party to agree to it, unquote. It may well be this is a point that employers want to bear in mind, particularly if they think that a judicial assessment may be unhelpful. So what is the status of this judicial informal assessment by the judge? Well, guidance states that anything said in the judicial assessment is not attributable and must be kept strictly confidential. It must not be disclosed to any third parties other than advisers, and this will be a requirement to be confirmed directly to the judge before the judicial assessment takes place. In conducting the assessment, the employment judge is only looking at the allegations. There's no evaluation of evidence, and it may cover an assessment of liability and or remedy aspects of the case. If the parties do get into settlement discussions and one of them is unrepresented, the judge will advise that the unrepresented party should have time to reflect on any settlement offer. If there is a judicial assessment, then that particular judge will not be involved in any part of the subsequent process, which involves the final determination of either of the parties' rights. They can be involved in day-to-day case management proceedings. My initial reaction reading this was it seemed to be a very sensible idea. Indeed, that remains my view. I think it will be interesting to see, however, what the take-up is. Employment tribunals have occasionally had sensible-sounding initiatives designed to resolve weaker cases, but which have fallen on stony ground. Bearing in mind that it takes both parties to agree to the judicial assessment, and that there is no pressure to be placed on either party, I think the initial take-up may be relatively slow. We'll see. The other point I would make is I'm not sure how the confidentiality provisions are necessarily intended to work. Are the comments made by the parties to the judge, presumably encouraging the judge to understand their point of view, confidential without prejudice, or without prejudice? Equally, parties may be uncomfortable with the fact that whatever information is given at the judicial assessment process will of course remain known to the other party even if they cannot attribute it. Equally, for employers, they may be concerned that a failure to be sufficiently robust at the judicial assessment process may simply encourage a claimant with a poor case to carry on. It would then be self-defeating. My other comment relates to the fact that the issues need to be clarified before judicial assessment can take place. This is a very sensible approach. However, for claimants who are unrepresented, they are the ones whose cases often need the most work at the case management discussion stage to clarify the issues. It's quite frequent for there to be requests for further and better particulars required and served on individuals. How is this going to fit with the indication that judicial assessment is given at the first case management stage rather than later? We'll see. All in all, I do hope this works and that some of the misguided cases and obviously misguided defences are weeded out of the process and that parties take a realistic approach. I do wonder whether it will happen, but I see that tribunals are encouraged to report the take-up of the process in each tribunal region, so it'll be interesting to see how this gets on. So those are the two cases and the judicial protocol for this week. Thank you all for listening. I hope you have a good fortnight. I'm off to buy Gina Miller a bottle of champagne, or at least send one through to her. And I will be back in 2 weeks' time with another fresh crop of cases, including the Uber case. That's a promise. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.